everyone, I'm Carlo, and I teach with the Accountancy Business and Management Department. Today I've been tasked to talk about a very important topic that's going to take on a whole new level of importance this school year. That topic is data privacy. My sources, by the way, are the following. First, of course, is the website established by the Philippine government specifically for the Data Privacy Act of 2012, which is privacy.gov.ph. Second is the online talk of Attorney Froilin P. Doyawen Pagayatan and sponsored by Vibal Publishing, which talked about privacy, plagiarism, and proper information in online teaching. Third is the online talk of Attorney Therese Ray Ann O. Aquino and sponsored by Rex Academy, which talked about the Data Privacy Act of 2012. So, without further ado, let's get on with our topic. Article 3, Section 2 of the 1987 Constitution states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. There is actually more to that section, but for this discussion, we'll mention just that. Article 3, Section 3 of the 1987 Constitution states that the privacy of communication and correspondence shall be inviolable except upon lawful order of the court, or when public safety or order requires otherwise as prescribed by law. Again, there's more to that section, but for this discussion, we'll mention just that. So, those are the foundations of the Data Privacy Act. The Data Privacy Act itself was signed into law in 2012 as Republic Act 10173. The Data Privacy Act was created for a whole host of reasons. It was created to keep people from improperly publicizing each other's personal information. It was also created to safeguard personal information given that it's much easier to transmit, store, and therefore abuse information now compared to decades ago. It was also created to prevent companies from improperly storing and using their customers' and employees' personal information. Most importantly, the law was created to keep the Philippines up to date with international standards of data privacy and protection. For this discussion, I'm only going to discuss and clarify parts of the law that impacts us directly as teachers. RA 10173 Section 2, Declaration of Policy. It is the policy of the state to protect the fundamental human right of privacy of communication while ensuring the free flow of information to promote innovation and growth. Wait. The privacy of communication while ensuring the free flow of information? Sounds kind of paradoxical, don't you think? Well, not really. What this simply states is that there should be a proper balance between both concepts. We want there to be free-flowing information to promote innovation and growth, but we also have to make sure this does not step on people's rights to privacy. RA 10173 Section 2, Scope. This act applies to the processing of all types of personal information and to any natural and juridical person involved in personal information processing. It seems that the operative word in this section is processing, so let's define that. RA 10173 Section 3, Definition of Terms, Subsection J, Processing. Processing refers to any operation or set of operations performed upon personal information including, but not limited to, collection, recording, organization, storage, dating or modification, retrieval, consultation, use, consolidation, blocking, erasure, or destruction of data. Processing is almost everything that anyone can ever do with data. It's almost like you breathe on data and that's already counted as processing. There are some exceptions though. Among the exceptions, the exception that we're concerned about the most is Section 4, Scope, Subsection D. RA 10173 Section 4, Scope, Subsection D, Exception. Personal information processed for journalistic, artistic, literary, or research purposes. The last part is especially important for us as we continue to conduct our respective departments' action research. While the purpose of research is exempted from various implementing rules of the Data Privacy Act, just to clarify, that doesn't mean that the purpose of research is exempted from all of the rules. Data collected for research can be allowed when the personal data is publicly available or when we have the consent of the person we're studying. Throughout the whole process, the rights of the people we're studying should be protected without compromising research integrity. When asking for data from our subjects, strict confidentiality must be practiced and it should only be used for the declared purpose. The data should only be used for the research we're doing. So, what is personal information? RA 10173, Section 3, Definition of Terms, Subsection G, Personal Information. Personal information refers to any information, whether recorded in a material form or not, from which the identity of an individual is apparent or can be reasonably and directly ascertained by the entity holding the information, or when put together with other information, would directly and certainly identify an individual. First of all, any information which, by itself, can identify a person is already personal information. Second, any information which, when combined with other information, can identify a person is already personal information. Personal information includes, but is not limited to, the following: name, address, place of work, telephone number, gender, location of an individual at a particular time, IP address, birth date, birthplace, country, citizenship status, payroll or benefits information, or any other contact information. However, there's also such a thing as sensitive personal information. The law treats both kinds of information differently. Personal information may be processed. On the other hand, the processing of sensitive personal information is, in general, prohibited. Sensitive personal information includes, but is not limited to, the following: race, ethnic origin, marital status, age, color, religious affiliation, philosophical affiliation, political affiliation, health, education, genetics, sexual life, court proceedings, bank details, government identification details, grievance information, and discipline information. Along with sensitive personal information are also privileged information. These are data based on the context of a legally protected relationship, such as the data between husband and wife, attorney and client, priest and penitent, and doctor and patient. So, to summarize this, we have to know that there is such a thing as personal information, and there is such a thing as sensitive personal information. Personal information can be obtained with consent and must be handled and stored very carefully. For sensitive personal information, we can only obtain it and process it if, number 1, the person consents to it, and number 2, we properly explain to the person what the information is going to be used for, and the person consents to this reason. So let's talk about consent. To put it very simply, the act of saying yes is what we know as consent. For the consent, or for the yes, to be valid, the consent must be freely given, it must be specific, it must be informed, and the consent must be clear and unambiguous. When is consent not needed? For as long as there is a valid contract between the person who processes the data and the person owning the data, consent is not really necessary, as long as the information is needed to fulfill the contract. The two contracts that concern us the most are the enrollment contract and the employment contract. For as long as the information will be used to fulfill the school's obligations to its students, such as for the creation of grades, submission of requirements to government entities like the Department of Education, taking care of the students' health, and other such reasons, then consent from the students is not needed because the school and its students are technically under an enrollment contract. For as long as the information will be used to fulfill the school's obligations to its employees, such as taxes, salaries, requirements, school safety, and other such reasons, then consent from the school's employees is not needed because the school and its employees are technically under an employment contract. Also, consent is not necessary when the processing of data is needed to respond to national emergency, to comply with requirements of public order and safety, and to fulfill functions of public authority. However, only personal information can be processed under contracts or during emergencies, even without consent. Sensitive personal information, on the other hand, always requires the consent of the owner of the information. Again, to process personal information, we don't need consent as long as the owner of the data is under either an employment contract or an enrollment contract. To process sensitive personal information, we always need consent. No exceptions. As teachers, there are two important principles of the Data Privacy Act that we need to keep in mind. The first important principle is the principle of transparency. The principle of transparency states that the owner of the personal data must be aware of the nature, purpose, and extent of the processing of his or her personal data, including the risks and safeguards involved, the identity of the personal information controller, his or her rights, and how these can be exercised. Any information and communication relating to the processing of personal data should be easy to access and understand using clear and plain language. The second important principle is the principle of legitimate purpose. The principle of legitimate purpose states that the processing of information should be compatible with a declared and specific purpose, which must not be contrary to law, morals, or public policy. And the keyword for this video is lobster. So, let's give an example of the things we've learned so far. Say, for example, we have a picture of a student who won a recent academic competition. Say, for example, we want to paste the picture of the student on a banner to proudly announce his win. Then we want to hang that banner outside the campus like we usually do. Do we have to ask the student for his permission? Yes. The picture directly identifies the student, and because anyone who looks at the banner can identify the student, then the picture is considered as personal information and it is therefore covered by the Data Privacy Act. Therefore, we need to ask for the student's permission before we can use it. But the student is under an enrollment contract with the school, so do we really have to obtain his permission? Yes. The posting of the student's picture on a banner is not a regular function and is not one of his regular obligations to the school as a student. Its real purpose is for promotions. Thus, yes, we need his permission. Do we have to ask the student's parents for their permission? Yes. The legal age is 18. The student's yes, the student's consent is not legally binding until the student is 18. So therefore, we have to ask for his parents' permission too. And for purposes of respect and goodwill, even if the student is already 18 or above, yes, we still have to ask the student's parents for permission. How should we ask for the students and for their parents' permission? Any form of media is fine, but any form that is in writing is best. We should tell the student and the parents exactly what we intend to do with his picture and the risks involved in it. At the same time, we cannot simply say that we're posting his picture simply to congratulate him. No, we have to make it clear to him that we are posting his picture as a banner to congratulate him, to announce his win, and as a form of promotion for our school. We have to be upfront and honest about this. Please note that even if the student says yes to our request, once the banner is posted, if the student changes his mind and asks us to take the banner down, we have to do so. It is still his face. It is still his personal information, and therefore, he still has rights to the processing of his personal information. So, for the protection of our students, we have to remind them that they should be very careful with their personal information. But out of all of their personal information, there are 3 pieces of information that they should never post in an online forum with a big audience. Never, ever. These 3 pieces of information are their full name, their birth date, and their learner reference number, also known as the LRN. If possible, usernames and online accounts should only have nicknames and last names, or even just nicknames. Full names must never appear or be posted online. Birth dates should never appear in a public forum. As much as possible, only the month and day should appear, but not the birth year. And no, don't post your age when you do your annual self-greeting birthday post, please. Trivia. Once, I needed someone's full birth date. What did I do? I simply scanned their Facebook profile looking for that day when the birthday greeting started appearing. And then, I simply looked for any birthday greeting post that stated the person's age. I mean, it wasn't even the person who stated his age. It was just a friend who did it. And by using simple arithmetic, full birth date acquired, it's not hard to do. With a full name and the birth date, acquiring a student's LRN is not hard to do. The LRN, or the Learner Reference Number, is a 12-digit identification number that is assigned to each student as a unique tracking key. This single LRN is to be used by the student throughout his student life. The Department of Education has a database for all of its students. It's called the Learner Information System, or the LIS. For someone like me who has worked with the LIS for more than 6 years now, and after seeing thousands upon thousands of LRNs in my career, I can simply look at a student's LRN, and by performing very simple arithmetic, I can estimate with a very high degree of accuracy the student's age, the student's current school, whether the student belongs to a private school, public school, state university, or international school, or even the enrollment population of the school. It's not hard to do. If you take the student's LRN and plug it into the LIS, then you can access the totality of the student's scholastic history. Yes, the LRN is that powerful, and therefore, that's how important it is to protect the LRN. So again, the full name, the birth date, the LRN, And any document which contains any of that information should never be posted online. If you want to post it online, at least censor that information. One more important thing you should learn about data privacy is the Supreme Court decision with the General Registry number 202666. You can search for it using the keywords Supreme Court GR 202666. The Supreme Court says, before one can have an expectation of privacy in his or her online social network activity, it is first necessary that said user, in this case the petitioners, manifest the intention to keep certain posts private through the employment of measures to prevent access thereto or to limit its visibility. And this intention can materialize in cyberspace through the utilization of the online social network's privacy tools. In other words, utilization of these privacy tools is the manifestation in the cyber world of the user's invocation of his or her right to informational privacy. In other words, the privacy settings on your Facebook or other social networking profiles manifest your desire for privacy. If you want to post something only for yourself, then set it to private. If you set your posts to public, or by not limiting the friends who can see your posts, you are outwardly stating that your information is for public viewing and is therefore not protected by the Data Privacy Act. Fellow teachers, let's keep our data safe, let's keep our students' data safe, and let's watch over each other. And fellow teachers, please know that the violation of the Data Privacy Act is considered a criminal offense. No, it's not a civil or administrative offense that only has fines. It's a criminal offense, which means guaranteed fines and jail time. Depending on the nature of the violation, the fines range from 500,000 pesos to up to 2 million pesos, and the imprisonment ranges from 6 months to 6 years. And so, to end this video, let me say that no, I'm not a lawyer. No, I'm not pretending to be a lawyer. And no, I am not an expert on data privacy. Even if you have questions later on about data privacy, questions like, Sir, can I do this? Is this against data privacy? Sir, can I post this? Is this against data privacy? Sir, can I copy this? Is this against data privacy? In most cases, I probably won't be able to answer them. In those cases, better ask for permission from the owner of the data, and from the principal, the registrar for scholastic matters, the cashier for financial matters, and the board of directors if in case it's needed. But just like anything else, if you have doubts about a situation, then likely it's the Almighty telling you not to do it. So just don't do it. If it feels wrong, just don't do it. If you're not sure, and if the matter is not a big deal anyway, then err on the side of caution. Just don't. So that's a brief summary of the Data Privacy Act of 2012. Again, I am Carlo Ang from the Accountancy Business and Management Department. Thank you very much for watching.